Okay. Let me put this on the record. State of West Virginia versus Autumn Ray Faulkner. It's 11-5. At this time, I have called this matter for a review hearing on my own motion. I've directed that Senior Trooper Loudon be present. Am I getting the Trooper First Class? I apologize. Trooper First Class Loudon be present and Prosecuting Attorney be present. I've also invited Mr. Mitzay and Ms. Faulkner to appear, as it is a hearing with regard to their case, even though this matter has been dismissed. Excuse me. On June 1st, this court dismissed this case without prejudice, largely because the prosecuting attorney failed to provide a CD containing a prior recorded statement of the alleged victim, a minor in this case, despite discovery being ordered and despite the fact that the defendant had specifically asked for a copy of that CD. That CD was crucial to this case, of course, for obvious reasons. Assuming the alleged victim took the stand in the case, the prior statement could be used to point out inconsistencies within his testimony. The State of West Virginia, through its prosecuting attorney, Richard Busch, told this court that Trooper First Class Loudon had essentially lost the CD and that it had never been in the possession of the prosecuting attorney, despite the prosecutor attempting to retrieve this evidence from the trooper on multiple occasions. In short order, following the dismissal, the word around was that this representation was possibly not accurate, that Trooper First Class Loudon had no fault in the lost evidence, and for this reason, to disclose, first of all, the word on the street in open court, and because I believe I do have a duty to set the record straight, particularly when we're dealing with law enforcement, I asked the prosecuting attorney to be present today. I asked Trooper Loudon to be present today, and I gave the opportunity for the defendant an opportunity to be present today. At this time, I would like to give Trooper First Class Loudon an opportunity to set the record straight, or for Mr. Busch to clarify his position before the court. Gentlemen, do either of you wish to be heard at this time?
You're already in regards to the CD being lost, that the CD has never been lost. I have a copy in my file. The Child Advocacy Center has a copy on their hard drive that can have been obtained at any point. My concern is that there was no evidence lost during this investigation. I just wanted to point that out.
Did Mr. Busch contact you repeatedly to urge you to find this evidence?
No, ma'am.
Mr. Busch?
Your Honor, regards to the comments that you've already said that I made last week, I think some of those were in response to questions from this court. Certainly, in repeating them back to me, they don't sound accurate. They are not. With regards to Trooper Loudon using the CD, I don't believe that. I know that's not the case. I don't know why I would represent that to the court. There was confusion as to the CD. As I recall, looking back at the matter, we had the CD with regards to the first case, and it got misplaced between then and the second and the following cases. And no reason that I intend to blame on Trooper Loudon. In fact, I called him immediately after the hearing and explained what happened, and explained it was still my fault. So I believe that any misrepresentation I made in the court was in response to the question was not intentional. With regards to the contact,
let me interrupt you for a second. So is it your position that you intended to represent on June 1st that your office had misplaced it, not Trooper Loudon?
The entire office's fault and responsible for the entire contact.
That's not what you said on the 1st.
Okay, that's what I intended to say. I think I said that. I made that point at some point during the course of that hearing. But I think there was some contradictory testimony I gave in response to the court's question.
Well, you didn't give testimony. You were addressing the court as an officer of the court. So anything else, Mr. Busch?
Just that, as I recall, I did try to contact Trooper Loudon with regards to the case once the plea offer was made. And as I represented the court, I did call him after that, but did not contact him. The issue with this is solely responsibility of the prosecuting attorney's office and not of the state police, not Trooper Loudon's. So, as I intended to do on June 1st, since I did not make it clear to the court that day, I've taken full responsibility for this in the absence of it.
Trooper Loudon, anything else? Gentlemen, I have a copy of the transcript from the June 1st hearing, and Mr. Busch, with respect to you, that is absolutely hard to believe, because the transcript is very clear with regard to the statements that you've made, and I'll read them to you. And I'll give a little bit of a preface here. Mr. Matsay finished his comments. The court was inquiring of Mr. Matsay. I said, thank you, Mr. Busch. And you said, well, let me start, Your Honor, with regards to the disc, the alleged review of the victim. And I think that maybe was interview. I contacted Trooper Loudon about that and was unable to find that. And the fact of the matter is, and then I interrupted you, and I said, does it exist, or are you contesting that it exists, or just saying you can't locate it? And you responded, I believe we can't locate it. So in that regard, we've tried to locate it and have not been able to. However, we don't feel that it is an absolute crux of our case, Your Honor. And then a few pages later, several pages later, actually, I was asking you with regard to the counseling records, the medical records of the alleged victim in this case. I said, was it requested? You said it was requested in the specific discovery. And I said, and did you do it? No, I did not, Your Honor. Then you refused to do so. How can you justify, first of all, how can you justify not turning over records that were requested without bringing it to the court for the court's consideration, number one, and number two, losing the CD with the victim's statement? Mr. Matsay says, Your Honor, if I may interject. I said, not yet. Mr. Busch, you said, I've never had that CD. I've never had the opportunity to see the CD. Now, that's a problem that we had with the investigation, Your Honor. I can't justify it or give you an explanation of why that has become an issue. The next page, still discussing the CD. I asked, but what if it contains exculpatory material? Your response was, I agree, Your Honor, but we tried to locate it. We can't locate the disc. The next page. Court, what efforts have been made to locate this CD, Mr. Busch? Mr. Busch, just repeat contact with Trooper Loudon. And he's indicated he would search for that. Is that true, Mr. Trooper Loudon? Did that ever happen?
I have never had to search for it. I said it was on the CDC.
Gets better. And he indicated later that he was having difficulty finding it and that he would get it to me as soon as he could. Is that true, Trooper Loudon? Then I asked Mr. Busch, when did you contact him? You said last contact was approximately 2 weeks ago. And when was the first contact, Mr. Busch? It would have been back in November with regard to the indictment that was dismissed in this case, after the November 3rd hearing. Several pages later, there was a discussion with regard to a CD about AT&T mobility. Mr. Busch says, okay, our office must be mistaken then. I don't have that recollection of the disc ever being in my possession. I remember talking to Trooper Loudon on at least 3 occasions, asking him to secure it, and him not being able to locate it at one point. Now, with those statements, Mr. Busch, and I'll give you a copy of this. I've highlighted where I've spoken, but I've read directly from the transcript from the June 1st hearing. How could there be any confusion with regard to what your intent was? Your intent had to have been to blame the lost evidence on Senior Trooper Loudon, First Class Trooper Loudon, which now you're saying, A, isn't true, that it was your office's fault when you get called on the carpet on it. B, which you're saying that you didn't say back on June 1st, that if that was my interpretation that I misunderstood. And C, when there is a full transcript to support what I've just read to you, how could there be any confusion that reasonable people could not determine that you were trying to push the blame off on a trooper, a first-class trooper, who was not present at that time?
I believe that transcript does contain repeated assertions that I was responsible for that disc. Now, with regards to what you read back in the transcript, some of those statements are accurate.
You said you never had the disc.
I didn't have it in my physical possession.
You said you had never had it.
Right.
Do I need to read that to you again?
No.
That's what you said. So how would you be taking the blame for the lost evidence? You said you never had it. Trooper lost it. You've called him several times. You talked to him 2 weeks ago, talked to him trying to find the evidence. You made repeat contacts with him trying to find the evidence, and he said he'd look for it. How could you have meant anything but to pass the blame on someone who was not here?
That was not my intent, sir. And if that's what happened, if that's the way the court proceeded, that was not my intent.
Mr. Midsay, do you have anything you'd like to say?
I think it's obvious, Your Honor. I believe these statements are material misrepresentations. I was here. I heard what was said. It was all about the CD and whether the CDs existed. What really bothers me, Your Honor, is that this CD has been in existence since the beginning of this case. It's obvious from the transcript of the one grand jury testimony of Trooper Loudon in response to some jurors' questions. It has never been identified. And then the explanations that were given here, it was clear to me from what I heard, it was clear from the content of, I'm sure, the total of that transcript, that tape was lost, that it was tried to be located, that the Loudon couldn't locate it, and he even tried clear back in November and couldn't locate it. So I think it's pretty clear as to what occurred here.
Anything else, Mr. Busch?
Yes, Your Honor. I was discussing some of the, or answering some of the questions you provided and you asked me that day. I was not necessarily referring to a specific time frame with regards to this case. The broader issue, what's been going on in the last year and a half of this case. And that's what I have to say.
And what?
That's what I have to say. Just that some of those answers given to this court may have been, in my recollection, from the 3 Congress cases that have been counted.
What about when you made the statement that you contacted Trooper Loudon 2 weeks ago to try to find it?
It was an attempted contact to try to find talk about the case. But it wasn't. The disc, I thought we had. It was confusion about the disc. I mean, it is what it is. There's nothing else I can say that's going to change this.
Trooper, is there anything you'd like to add? All right. Mr. Busch, you have to understand that your actions have consequences. You're dealing with the reputation of a trooper who has served this community and the state for many years. You're dealing with his credibility. The statements you presented to the court on June 1st could have caused this trooper a promotion and, quite honestly, could have caused this trooper his job. Do you agree with that, trooper? Those statements you're now disputing, but it's in black and white. There's no way to dispute what I'm reading. I have no choice at this time but to find that you, the prosecuting attorney, has made material misrepresentations to this court. Accordingly, for that, I'm holding you in contempt. I'm going to defer ruling with regard to what the sanctions will be, and I will set the matter for hearing probably towards the end of the month. All right, this hearing is adjourned.